My name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Freund versus Washington Square Press. This case is heard in the New York Court of Appeals, which is truly the New York Supreme Court, in the year 1974. Let's go ahead and jump into the facts of the case. So Freund and the publishing company, Washington Square Press, had a contract. So this is a contract case. The contract said that, hey, Freund, you're going to write this book, which is great, write the book. You can give it to us. When you give us this book, we'll give you $2,000. Give you $2,000 as a, hey, thanks for writing the book. And then we're going to look at it. We have 18 months to decide whether or not we want to publish it. If we publish it, then you're going to get royalties and all this money, and it's going to be great, and you'll get notoriety, and life's going to be good. If we don't publish it, we'll give you back the book, and you can keep the book, and you can also keep the $2,000. So, Freund gave the publishing company the book. The publishing company merged with another company. Ultimately, they didn't publish the book. Freund got to keep the $2,000. Freund didn't get the manuscript back, but in the process of the legal proceedings, he did get the manuscript back. So he had the manuscript back and the $2,000. Freund still argued for some damages. Freund wanted some damages. And so this case deals with a remedy. Damages, how are we going to assess damages properly for a party when there's a breach of a contract? So the trial court ruled not completely in favor of Freund, but they did on one aspect, and they said that because Freund is now going to have to self-publish this book, the Washington Square company should give him $10,000 to try and self-publish that book because they broke the contract and didn't publish the book. The publishing company probably had a lot of attorneys, and they weren't happy with this, so they went ahead and appealed it. And they appealed it to the highest court in New York, and that's where this decision comes down. The court ultimately rules that even the $10,000 that was given by the trial court as damages, and the Court of Appeals as damages to Freund, was actually not proper. He shouldn't have even gotten that $10,000, they say. They say that because there was no guarantee in this contract that by publishing, that they were ever going to publish the book. There was no guarantee that the book would ever be published by the publishing company if Freund submitted it. The only guarantee was that, hey, you're going to get $2,000 and you're going to get your manuscript back if we don't publish it. So the court discusses this for a little bit. Ultimately, they say that the job of the court in seeking remedy for plaintiffs in contract law is not to put them in a better situation than they would have been, if the contract wouldn't have occurred. It's really just to put them back in the same situation that they would have been if the contract didn't occur. And so for that reason, the court says, hey, you can't have the $10,000. We're going to give you 6 cents in total, and then they'll give them attorney fees because they did breach the contract by not returning the manuscript in a timely manner, but they didn't breach the contract by not publishing it. There was no requirement that they were going to publish the book. There was also no requirement or no guarantee that by publishing the book, now Freund's going to make a ton of money. Who knows if anyone ever buys this biography. So that's the ruling of the court. There's one quote that I think really illustrates well what we're discussing here. It's just, damages are measured by the natural and probable consequences of the breach to the plaintiff, not by what the defaulting party saved by the breach. So yes, the publishing company did save a lot of money by not publishing the book. But what was the real damage to the plaintiff? What was the real damage? He had no guarantee in the contract that he was going to get this book published. All he had to guarantee was $2,000 in his book back if it didn't get published, and he got both of those. So that's why they only rewarded nominal damages. So that's the case. All right, so let's go ahead and jump into some ex ante implications. The first one is, there's 3 different types of damages. There's expectation damages, there's reliance damages, and there's restitution damages. So the court in their decision does consider all 3 of these damages. They note that Freund didn't really bring a claim on reliance damages. And I think it would have been interesting if Freund would have, if Freund would have said, hey, I wrote this book, took me 2 years. I, had so many other things I could have been doing, but I was writing this book. I relied upon this promise. Would that have changed the decision? I don't think it would have, but it just definitely would have been more for the court to tango with if he would have raised the claim on reliance damages instead of just the expectation damages that he had. And like the court said, we can't expect to put a plaintiff in a better place than they would have been if it weren't for the contract. The breach is just to give the plaintiff what they could have reasonably expected if the contract were to have occurred. Another scenario that I like to consider is just, this definitely lays out some law for contract law. And when I say law, I mean precedent. Lawyers, attorneys in the future are going to want to make sure that they're very clear in how they draft what will happen for remedies and damages in the case of a breach. Because there was no clear, hey, if we don't publish the book, then we owe you $15,000 so you can go publish it yourself. The court didn't rule in favor of Freund trying to get that money to go publish it himself. Had there been a clause in the contract that says, hey, if we give you the $2,000 for writing the book, we hold it for 18 months, we decide we don't want to publish it, then we're going to give you $10,000 so you can go ahead and publish that on your own, we would have had a very different contract. So this just incentivizes attorneys and contracting to parties to be very aware and keen to what would happen if there was a breach, and how do we want to lay out the remedies for those types of breaches in the contract that's at hand. So thanks so much for watching. Hope you have a great rest of your day. If you enjoyed this video and you'd like to see more of them, go ahead and hit the subscribe button, and I'll talk to you later. Bye-bye.